Attorney Jennifer Witt here with 3 things you do not want to say or do in court, and I'm going to give you one hint of something you always want to do in court. So stay tuned. Hi, Attorney Jennifer Witt here. If you have a criminal case coming up and you're expected to be speaking in court, 3 things I think you should not say to a judge, or you should be thinking about at least. And I bring this up because I saw a couple of these recently in court, and it really gave me the cringe. And I'm sure the defendant maybe didn't realize that he was doing a couple of things that was irritating the judge. So number 1, don't interrupt a judge if at all possible. Sometimes you'll see attorneys do this, and even we know it's a matter of last resort. You don't want to do it, and you preface it with, "Your Honor, I am so sorry to interrupt you. I really need to clarify something on the record." So again, just really try not to interrupt the judge unless you absolutely have to. And that's not because you think they're saying something you don't like, because you can follow up with, "Your Honor, may I clarify something?" But don't interrupt the judge. Number 2, you cannot talk about your case. If you aren't in trial, or even if you are in trial, your attorney is doing the talking unless you're on the stand, the witness stand. So don't try to get facts in at your arraignment or a pretrial hearing. The judges get so frustrated. They have long calendars. They're trying to keep it under control. You're not allowed to just openly speak about the case. Procedurally, that's fine. You know, whether you have another case open in another court, or a pending charge somewhere, that's fine. What it's about, the facts of it, your involvement in something, that goes to the facts of a case, and a judge can't have that on the record. It's because those words that you're using are recorded and can be used against you later. So the judge does not want you to speak about your case. Sometimes people just think, "Oh, if I just told you this one fact, you would realize, oh, you could just dismiss this, or you have this, it's a misunderstanding." Don't do it. It really irritates judges, and you can't do it. You can't just speak freely about your case at an arraignment or a pretrial. So don't do it. Don't try to do it. It just blows up in your face. So number 3, don't blame people. And I understand we have situations where we have clients, and maybe they got bad advice, or probation told them to do something, or didn't, or that they were fine and they had completed all of their conditions, and but it just looks so bad when you come into court and you're like, "Well, this motion to revoke is because probation is a bunch of idiots." Like, no, that is not what the judge wants to hear. They work closely with probation. Often people within the court are friends, acquaintances at least. Just say, your attorney should be speaking for you, but if there was a misunderstanding, handle that respectfully, and you say, "Your Honor, I think there's been a misunderstanding," or your attorney should be saying that. That would be a better situation. But if I did see this in a court last week, where the person started with, "So-and-so's an idiot, and but for that idiot, I wouldn't be here today." You can imagine that didn't go over very well. So don't do that. Whether it's I hate my lawyer, and this would all be fine if I didn't have this idiot lawyer, or I have stupid public defense, or the probation, it's their fault, and they told me the wrong thing, and they're idiots. A lot of calling people names and blaming other people. And again, I'm not saying it didn't happen, because mistakes get made, or people get advice, from the clerks who shouldn't be giving legal advice, or probation didn't notice something, and so they misinformed you. Something that your attorney will get cleared up, and it will get resolved. But boy, did that tick off the judge. So don't blame anyone when you get called into court. You can say, "I'd like some time to get clarification on this," or your attorney will say, "We're going to present some documents regarding this," or "Can we get some time, get another court hearing, a pretrial, and we will have this resolved at the next date." Things like that. But blame game, no. Again, I'm doing this because all of these scenarios that happened, someone was representing themselves. They were pro se. They, for whatever reason, didn't want an attorney, or maybe public defense hadn't yet been assigned, or they didn't show up. So it was just not good. The individual didn't understand what was appropriate. So one thing I want to finish with, what you should do if you don't understand, or you are frustrated and you do feel like you are getting bad advice and probation did tell you the wrong thing, or you're not really, and a lot of this lingo we're so used to, and maybe you didn't understand, be sure to ask the judge or go to the clerk's office, or depending on your question. But if you're in court and you don't understand, it's perfectly fine to say, Your Honor, could you clarify something for me? I don't understand what my next date is, or where am I supposed to go? And the judge sometimes will speak quite quickly and say, check in with probation, go to pretrial services, and you don't know what pretrial services is, and you don't know what you mean by check in. Do I call them? Do I go there? Often there's a clerk there that can help you in court, or the clerk's office, whether you're in district court or superior court. But it's okay. The judge isn't going to spoon feed you, well, first do this and then do that. But if it's something that you just don't understand what the judge just said to you, it's perfectly fine to say, Your Honor, I have a question about what you just said. And that's probably how you should say it, so the judge isn't afraid that you're going to start talking about your case. So you say, Your Honor, I do have a question about what you just said. I don't understand what pretrial services is, or I didn't quite hear what date you set. Does that mean, I need to appear in person? Maybe you want to clarify that. Can I appear virtually on Zoom or another platform? So be sure to know you should do that. I absolutely understand people are so nervous and they just want to get it over with and get out. So I just want to get that out there. There are 3 things that I noticed recently that really bristled the judge, and I think probably hurt the defendant in a way that he didn't quite understand. Might have just been kind of his a more abrasive nature, but be careful about that. And finally, always feel, not just, you may not feel comfortable, but understand it is important for you to advocate for yourself. If you are not going to have an attorney there, which I definitely do not advise that, or you don't know what you don't know, as they say, but if you are there alone, be sure to clarify things like future court dates, where you're supposed to check in, if you have conditions of release. Be clear on what those are so that you don't ever violate a court order or fail to show up for a court date. So I hope that's helpful to you. I know it's easy for me to say that, and there are a lot of things that happen in quick time, and people are using lingo you don't know, but hopefully that helps you prepare and have it go as smoothly as possible. So thanks for watching, and I'd really appreciate it if you'd hit like and subscribe. Thank you.